Hi, this is Matt Lindy, and I'm going to spend the next few minutes talking about the revocable trust. The revocable trust for certain people can be very beneficial. However, I have seen lately an awful lot of people come to me after the death of a mother or father or another loved one when the person who died has established a revocable trust and they didn't really need it. And actually establishing the revocable trust in some cases causes additional expense after that person's death. Well, let me explain how with a couple different scenarios. The first scenario is a husband and wife. Let's say that they had $30,000 and a house. The house in this market is worth approximately $120,000. The wife dies first. The order doesn't really matter. Then the husband dies, and then the child comes to me. And they come to me with a will and a trust. Now, if you set up a trust, it's critically important that you actually fund that. And what that means is you have to transfer property into the name of the trustee. If you don't do that, the trust has not been funded, and it becomes a relatively expensive document that collects dust in a safe deposit box. Well, back to our example. So the person comes to me and they say, Mr. Lindy, we have a house and $30,000 and it was in my dad's name. And we have a trust. And what the will says is the will says, upon my death, all my assets shall be transferred to my wife if she survives me, but if she doesn't survive me, then it shall be transferred to the John Smith Revocable Trust. Okay? Well, we have real property, and real property now is in the name of the deceased father. It has not been placed in the trust, and so now we have to transfer to the trust to transfer to the beneficiary. A complete waste of an extra step. The people, the husband and wife with the $120,000 house that was their homestead and the $30,000, they didn't really need a trust. In fact, I could do a summary proceeding, which is a form of a probate, except it's abbreviated. Since the house is technically not part of the estate, the $30,000 is under the $75,000, which is the limit for estate assets. If you have more than $75,000 of estate assets, you have to open a full probate. But the homestead is not counted as part of that. So in that scenario, I could have done a summary proceeding and transferred the assets to the beneficiary relatively easy if there's no creditors. So the trust created a big hassle. Another problem I see a lot of times with trusts is this. In Florida probate law, if you have a revocable trust, meaning that the decedent could change or amend it during his or her life, and a creditor wants to get at that trust after the decedent's death based on something the decedent did. Okay, let me give an example. The decedent had a hospital bill of $40,000, wasn't paid. The hospital wants to get paid, the decedent passes away. Now the hospital wants to go after their trust. Under Florida law, they have 2 years to open a probate, file a claim in probate, and then once the claim has been established, the personal representative of the estate can then go after the trust. Well, let's imagine that you are the trustee of a trust and you're not sure if your mom or dad or aunt or uncle or whoever had any bills. And the person passes away January 1st of 2011. If you don't know if they had any bills, and let's say there's $300,000 in the trust, are you going to distribute the assets of the trust? Well, if you go to an attorney, they're going to say, look, there might be creditors, and you're not really going to be free of these unless you do one of two things. One thing is to wait 2 years. Well, imagine if you're going to be receiving $300,000. You don't want to wait 2 years. You just soon have your money today, thank you very much. Or the other scenario is you open an estate and file a creditor claim or publish notice. It's called publishing in the newspaper notice to creditors. Well, if you have to open an estate to publish notice to creditors, then what was the whole purpose of the revocable trust? Because I thought, and many people sell trust this way, it's to, quote, avoid probate. And now you're opening a probate for the purposes of noticing creditors. There are reasons for a revocable trust, and I will go into those in another video. But many times these documents are sold, and I've seen them sold by door-to-door, quote, insurance, unquote, salesmen for like $2,000, $3,000 that are pre-printed documents, 50 pages long, that were printed from a company in California. I've seen them sold by attorneys who really don't even understand the issues of creditor claims and see a trustee can't publish a notice to creditors. So there's a lot more than just setting up a trust. And if you believe that that I must have this, it's going to be very beneficial, well, give me a call, because I'll be happy to talk with you over the phone and tell you whether under your circumstances a revocable trust is the best option for you. Because many times there are other options. And setting up a revocable trust and funding it generally costs more money than doing several other options.